Good morning. Welcome to RSC Conference 2024. Next 50 minutes, we'll go over the topic around living in a material world. During the Q&A session, please use microphone located in the center. Thank you.
Hello, good morning, everybody. Am I on? Oh, okay, I guess you can hear me. Thanks for coming. Welcome to Living in a Materiality World. We're going to have a fun session. I'm Jim Shreve. I chair the cybersecurity practice at Thomson Coburn. I'm based in Chicago and DC. I've been doing privacy and cybersecurity work for about 25 years, advising clients on those issues. My co-speakers.
Chris Pearson. I'm the CEO, founder of Black Cloak, two-time CISO, and a recovering attorney. What's interesting is I put out, I don't know if you saw it today, but I put out 20 years ago, I did an RSA speech, but we were in the Metreon. And so you had to stand down there, but you know what you didn't know going into it, it was my first RSA speech, you had to like look up angled at the letters that were on the screen, because of course it's like a huge cliff wall there. But this is gonna be fun. We're gonna have a lot of fun today, a lot of fun.
And I'm Steve Black. I'm a professor at Texas Tech University.
All right. Excellent. So we're gonna move along quickly today. We only got 50 minutes. We're gonna get through a lot of material. So I'd say the session's going to be kind of in two parts. We're going to talk for a while, and then in the second half of it, we're going to go through some exercises. If you have questions, chances are the questions are going to be pertinent to what we're going through in the exercises. And you get to participate, you get to vote on things, you get to decide what's material. So that's probably where the questions will go. Let's start off with, do we have any attorneys here? Awesome, love attorneys. We didn't design it for you. Sorry, it's not all about attorneys, but we're thinking mostly about the CISOs here. CISOs are where the rubber meets the road on determining materiality in cybersecurity, and so that's kind of what we geared it for. Attorneys, you're going to get something out of it too, I hope. But kind of CISOs are what we had in mind. So with that, materiality. What is it? Let me give the disclaimer here first. So you can see this. We're blah, 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 all the legalese. Okay, so.
There we go, the most important slide.
Yes, the most important slide, what it's all about here. So materiality, I'm liking to say, is the new reasonableness. So reasonableness has been the biggest buzzword in cybersecurity for, 25 years. Materiality is the new word that's coming in, and it's a different calculus, but it's in some ways similar to reasonableness. And we're going to kind of go through how you figure out what it means. Mainly, we're going to talk about the SEC requirements here today, but materiality comes into a lot of other ones as well, and it's propagating itself in many places right now. So. In the last several years, we're seeing many requirements that mention materiality. And so with the start of that, let's go with an oldie but goodie here.
So, I mean, that word is something materiality. For those people that pay attention to GAAP, right, generally acceptable accounting principles and procedures, whether you just pay attention to old case law, is it material, not material, what does the judge think, what does the jury think, all the rest, we can point back to controls or critical controls, either operationally or financially, and having some type of nexus by which CISOs, and I was in this role, have to go ahead and examine, I have to talk to the CFO. I have to go talk about is something material or not, as early as Sarbanes-Oxley in a really holistic fashion. And that's really probably where, right, whether information is material, information. That's really where this all started in terms of CISOs, and sometimes at that point in time would be directors of IT, directors of information security, having a seat at the table. But it's going to be those 25 years of discussion of materiality from Sarbanes-Oxley that gets all pulled forward into SEC and other state laws and guidance there.
Okay, so talking about those SEC requirements. Everybody knows the SEC issued new rules in December. Became effective in December. New rules on public disclosures of cybersecurity risks and incidents, but the whole idea is not new. The SEC has been talking about this for years, and they'd say It actually goes way back before they even started talking about it. But so they issued the first guidance came out in 2011 from the Division of Corporation Finance. Talked about making disclosures about cybersecurity risks and cyber incidents. And one of the things they did make clear at that time, the real point of it was differentiating between what's a risk and what's an incident. Make sure you're saying not just that you have a risk of an incident, if you haven't had an actual incident. So they gave guidance on what they expected to see in your public reporting. There, the primary thoughts was about your 10Ks and 10Qs. But we moved towards other ones later on. So 2018, we had further guidance. This was from the commission as a whole that gave additional specificity, additional guidance on what the expectations were. But in both cases, if you have a material event and you're a public company, you need to be reporting it. And so they would say, all this stuff isn't new. But Steve, the most recent.
And just a quick one on that. The thing I love about this in 2011 is that the SEC stated that this guidance is not guidance in the guidance, and they said this rule is not a rule in the guidance, which is just utterly confusing. But for those banks at that point in time, and I was at the Royal Bank of Scotland, that didn't pay attention to it, they got majorly slapped. That was back when DDoS and was happening. And so some banks got it then. The other thing to pay attention is 2018, they spent a lot of time talking about thou shalt not make trades during an incident. A lot of time. It's kind of hidden in there, but it's always a good board refresher, especially given some things that have happened in the recent years. Sorry, go ahead, Steve.
No, we're good. So, last year, exciting stuff, kind of, right? Unless you actually have to practice in this area. So what have we got? The SEC finalized a regulation that changed reporting, added an item to the 8K and the 10K if you are a publicly traded company. Well, that's fun, right? It's just a little item, not all that big of a deal, kind of a big deal. So what is it? We need to figure out what the material aspects of the nature, scope, and timing of an incident. All right, nature, scope, and timing. And we also have to disclose the material impacts or the reasonably likely material impacts. And if that doesn't make your head spin just a little bit, then you haven't been paying attention, right? Well, reasonably likely, so we're looking into the future, trying to decide what I need to report. When do I have to do this, right? I've got lots and lots of time. It's going to be really easy. This report is due, or the 8K is due 4 days after the trigger. All right, so what's the triggering event? Triggering event is that we've made a determination that the incident is material. So as soon as we discover that there is an incident, the clock starts running. Clock starts running because how long do I have to determine whether the incident is material? And the answer is without unreasonable delay. And originally it was as soon as reasonably practicable, and that just doesn't trip off the tongue all that well. So without reasonable delay, we could, argue semantics there that one of them's positive, one of them's negative, so I could act and someone's going to have to come and say, well, you acted with delay, and I could say, no, it wasn't, but the word is without reasonable delay. So to sum all that up, new rules are this. If there's an incident, I need to be thinking about whether or not it's material immediately. And as soon as I make that determination, then I have 4 days to report. And that's what we're looking at now for the new rules.
Okay. Anybody here at an entity that is subject to New York DFS cybersecurity regulations or advise companies that are? Okay, so some of you are familiar with this. Anybody have a guess how many times the word material or materiality appears in that current version of that regulation? I'm impressed if you can come up with this. 23 times, which I think is pretty impressive. It hasn't been really focused on nearly as much as the SEC requirements, but I think it's very important. So it comes into a number of places in here, including in the definition of cybersecurity incident. 2 of the 3 prongs have materiality in them. A CISO has to report at least annually to the board or a senior governing body about several things, including these things you see up here: material cybersecurity risk, material cybersecurity events, plans for remediating material inadequacies, and material cybersecurity issues. So if you're expected to report to them on this stuff, you got to know what's material. You got to figure it out. And on the audit trail, you're required to maintain information systems that are designed to reconstruct material financial transactions and include audit trails designed to detect and respond to cybersecurity incidents that have a reasonable likelihood of materially harming any part of the normal operations of the covered entity. As well as you're required to report annually to DFS on that the entity is materially in compliance with all of the requirements of the cybersecurity regulation. And so, if you're not even if you're not an entity that's subject to NYDFS, you may say, okay, we don't have to worry about that. We're not under DFS, even if we're a financial institution. Well, the problem is that has become a model, and so we have a model cybersecurity law put out there for insurance companies. DFS's regulation is the model for that. The FTC's cybersecurity safeguards rule under Graham Leach Bliley, based on NYDFS. So it's getting out there. Like California has been the model for privacy laws, DFS's regulation is the model for cybersecurity requirements. And so you can expect to see more a discussion of materiality as this flows through the system.
Yeah, this is definitely one of those benchmarking laws. Even if you're not subject to it, benchmark.
Yeah.
State data breach laws. Look, requiring notice where an incident materially compromises security, confidentiality, or integrity of personal information. Look, since SB 1386, what was it, 21 years ago this July? I'm having a big party. Everyone's invited. Yeah, it's been out there for a while, but ever since that law came on the forefront from, once again, California, and then evidence of 3 laws, then 5, then 8, and then right up at the full U.S., material has always been part of that quantitative analysis. At this point in time, it really is a little bit more simplified. Usually people don't say, we just want the first name and last name information, maybe an email address, but we don't want the social security numbers, we don't want the financial information. They're looking for the full thing. They're looking for the whole thing, and to either exfiltrate it all or to use it or to extort off of it. So it becomes perhaps a little easier to make a determination of, is this a actually legally cognizable data breach under one or more of the state laws? And as a result, do we have some type of a requirement that we provide notification to potentially affected and or affected customers of that client and or regulators? But once again, been worked into those different state laws since July 1 of 2003. And there have been multiple interpretations, multiple changes of it. Once again, it just further stitches together the fact that this ain't new. And there's a big, long roadmap to look back at to figure out how to work under the new SEC regs.
Oh, good. Any Princess Bride fans out there? Oh, we're so timid about that, right? So this is the word that doesn't mean what you think it means. I butchered the quote. Don't make me do it, and don't make me do it in an impersonation voice, because I'm not that good at it. But we need to talk about what the word means, and if we can do the next slide. All right, is this the point where I get to brief cases? No, we just want, tell us what we need to know so we can walk away from here and seem smart to everyone. You're smart to everyone, but let's talk about what materiality is without going back decades and decades. Let's talk about some benchmark cases that we should be aware of. So TSC Industries, here's what happened. Anyone, right, we've all had this experience. I build a family business and then somebody wants to come and take it over and they don't want me anymore. It's a little bit hurtful, but for the fact that they give me millions and millions of dollars. So that's what happened. And then the people had taken over TSC, had jointly issued a proxy statement with TSC to the shareholders saying, we're going to dissolve the corporation. It's all going to be fine. But what they didn't disclose is that management had changed. and that there had been this takeover and that things were a little bit different than they were before, and some disgruntled shareholders decided to sue. And so here's what the Supreme Court said. Is there a, quote, substantial likelihood that a reasonable investor would consider the information important in making a buy, sell, or hold investment decision or voting decision? That's a lot of words there, right? Is it important? Number one, and we're going to have to talk about what important means because we're lawyers and we like to do that, and it just goes on and on and on and on, and that's how we make our money. Number two, who is it important to? Right? We can talk about materiality in a whole lot of contexts. But in this context, it's a reasonable investor, or in other words, somebody that might find the information important. All right, so let's hold on to that for just a minute. Second case that we have here from 1988 is Basic Inc. And in this case, it wasn't something that they had said, it was something that they hadn't said. So there was a whole bunch of trading going on, and people started asking, why is there a whole bunch of activity in your stock? And they said, under no circumstances are we talking about a merger. No, I'm sorry, that would have been bad. What they said is, we do not have a merger agreement. When in fact, what was happening was they were talking about merging. And so the question was, well, was that just a little white lie, or is that securities fraud? So part of materiality is going to be what you say. Part of it is going to be what you don't say. And the whole understanding is we need to disclose information that an investor would find important. And we need to do so in a transparent and honest, did we use that word honest? Is that such an awful word?
We should use it.
We probably should. Manner. So that's what we're looking at there.
Materiality. Factors in looking at materiality. Look, there is no affirmative list of these are the 20 things that you must examine, all the rest. But the SEC actually does a pretty good job of laying out some of these items. Total mix of information. This is one of those things where it's a little bit of a, okay, we're gonna pass the buck for now. You got to take a look at everything, both qualitative and quantitative measures. I want to stress that it is not just a quantitative analysis. You could lose $1 and have to report a material cyber risk or a material cyber incident. $1, 99 cents, whatever. Could be direct loss from an incident, downtime, repair, outside resources, right? That's where the financial comes in. Likelihood of incurring some type of a loss. It could be loss of money, it could be loss from lawsuits, it could be loss from partnerships, opportunities, deals. Possible harm to business partners and other entities. For all the third-party breaches, hey, we're Acme Widget Company and we service 200 of the top 500 Fortune 500 companies out there, right? This could be a pass-through type of cybersecurity operation, and that could have massive, massive impacts. Reputational impacts, reputational harm, always the catch-all. This is one of those things that just gets bolted in, bolted on, and you could go any way on just about any deal. And then litigation or regulatory enforcement risks. The fact of the matter is that litigation is going to be on almost any single thing that you put out there. You say you got a cybersecurity risk or a cybersecurity incident, you're going to have litigation. The question is how much money you're going to spend on it, the set aside for it, how much does that impede business? There is an interesting article that is out there by Malcolm Harkins, so a good friend. It talks about material by impact and material by nature. So some things are just naturally, like you look at the numbers, you look at the figures, and it's material, period. We all agree it's material. The other is the material by impact. It comes up with a Rubik's Cube formula for how do you assess that. I would definitely strenuously suggest to folks that they take a read. It's 6-7 pages. Take a read through that. I think that those are going to be the things that need to be built into your ability to actually quantify, to qualify whether this is material, because the SEC is going to take a similar view. And we're at the point in time where we're going to go fast to go slow, so we can go through things. All right, Jim, take it away. Marriott.
So we're going to go through a number of companies' filings. We're not calling anybody out here. These are things that are in the news. You've seen them all. You know the facts. Just to kind of show you what's been in these filings. So, Marriott Starwood, very well known. Everybody knows what happened here. So, noteworthy here, this happened, this was discovered in September of 2018 in their first 10Q that was filed after this was discovered. Really didn't go into it. So we don't see anything that's specific about this incident at that point, even though it was filed at the end of September. It was filed covering through the end of September. So then, moving on. They then file an 8K. So 8K, so more pressing. So important incident outside the normal filing. So it's not in the normal schedule like a 10K or a 10Q. This is a special event. So they file an 8K and included answers to 3 FAQs that relate to the incident here. So their first reporting on it is end of November. And here you can see what they had. And it includes a link to a press release about it. So later on, so we get into the first part of the next year, that we have another 8K. We have a third 8K that comes at the end of February, and it describes some of the financial results from 2018. And you can see some of the language that they included here about the incident. Another 8K comes midway through 2019. So you get to their 10K, so their annual report, and here are various paragraph leads. So I didn't include all the language because it's much too long to see here, but you can see what they're talking about. These are the headers that they have, and I would note this thing at the bottom here. A section on Starwood has been included in every 10K and 10Q ever since, still including it today as part of the reporting. So think about that. The effects of this stuff can be pretty long. And we can question whether or not that's the best idea, but this shows you what we've seen. So we had the new guidance come out in 2013. So let's talk about what we've seen on that since that time.
And as Jim mentioned, we're not poking fun at anyone. We're not putting you up saying, oh, look at what an awful company this is. In fact, this may be a little bit of free advertising, but we're going to take a look at some examples just so we have some language in mind and we can start to think about it before we get into the interactive portion of it. So you may be wearing some of this clothing here if you like North Face, Smartwool, Vans, Dickies, Timberland. Do you want me to keep going? We can go on and on and on. So it's probably bad if you are an online retailer to have your systems go down in December. Can that go without saying? Okay. So, and then to have them go down because somebody took 35 million-ish customer records out of your system. And so, what do you say about that? The incident we're looking at the blue language here, and is reasonably likely to continue to have a material impact on our business operations. Skip down. We haven't yet determined whether the incident is reasonably likely to materially impact our financial positions. Okay, that's a little bit of a smoothing over of the language. I like that, right? It's good. Have we disclosed what we need to and let people know? Yes. But we haven't yet made the determination about whether or not this is financially going to impact us or operationally, at least did for this holiday season. All right, what do we have next?
First American, so once again, in association with kind of the home and loan space area and titles, right, cannot estimate the duration or extent of the disruption at this time. So once again, this is an operationally focused risk. Operationally focused risk that they're letting people know about because it's going to have downstream repercussions. And then also here, the company is assessing the impact of the incident, whether it may have a material impact on its financial condition and results of operations, which at this point cannot be determined. Once again, we kind of have that placeholder language in there. What's interesting about both VF and First American is that theoretically, every single person in this room, we could give you 60 seconds, you could go pens up on it, you can write out a statement right now that is hey, something happened. We're working with A, B, and C, vendors, companies, FBI, whatever, to go ahead and try to figure it out. We don't know the full scope of it, but as of this moment in time, we haven't determined that it's material and be all done and said with it. And that's probably, as you're reading through some of these statements, think about, can you have these or variations of these or 5 or 10 of them, whatever, that are all stamped and approved and all set so that when, right, not if, but when that event happens, You don't have to run and try to get a whole bunch of people to wordsmith 4 sentences that'll take you 4 days.
Okay, next one, United Healthcare. So February attack at Change Healthcare, which is a subsidiary of UHC. So it primarily impacted healthcare payments, but the attackers did get access to some patient records, not a significant amount. UHC filed an 8K on February 22nd. We see the language from it here. And see what they said about it at that time. Later on, after we submitted our slide deck, they filed an amended 8K on March 8th stating they were mitigating the effects, and as of the date of this amendment, the company has not determined that the incident is reasonably likely to materially impact the company's financial condition or results of operations. They then filed another amended 8K on April 24th, which referenced a press release, which interestingly had no discussion whatsoever about whether it was a material impact or not. So significant incidents, been a lot in the news, but so far they have not said it's material to their operations. So.
Okay, I know that all of us work for organizations that just do business in one location. So we need to consider the question, what do I do if the breach happens somewhere else? So if I'm a worldwide logistics company, where do I do business? Answer, everywhere. And bad things happen in Canada. Anybody here from Canada? Welcome, right? There you are, thank you. So, is it material for the US SEC purposes that something bad happens somewhere else in the world? What do we say? Look, number one, we're taking care of this really, really fast. That's always a good thing to say, right? It's not going to bring us down to our knees. We've got it. We found it. We're in the process of fixing it. But it didn't have a material impact on the company's overall operations because we're big. All right, is that material? And the company has not determined the incident is reasonably likely to materially impact the company's financial conditions. And guess what? It didn't happen in the United States, and we're operational here in the US. It's just that other country. They're a neighbor, they're a friend, they're an ally, but we're not going to talk about them because this is the US SEC. It's an interesting type of disclosure. Is it material? Absolutely. Why? Because if I'm worldwide logistics, anything that happens anywhere in the world, would an investor here in the United States want to know about it? And that's really the question that we're trying to tie down.
Okay, so now the fun part of it. We're going to play the SEC's favorite game show. Is it material? So, and this is where you guys get to participate. So we're going to go through some scenarios. We got about 6 of them we're going to talk about. 6 actual incidents. We don't name names on the companies. You may be able to figure out who they are. You may be at your company, who knows. But we're going to give you some facts about it. Since we don't name who these companies are, and a lot of the facts are not going to be out there in the public, if there's things you want to know in terms of figuring out if it's material, ask us. We'll make up the facts. So, and let us know what you want to know. So this is participatory. So ask us questions. We'll go through each one of these, and then we'll vote. Do you think it's material? It's got to be reported or not material?
And just shout it out.
Yep.
Cause confusion. We got mass chaos in this room.
Well,
Just go for it.
dealing with these incidents is confusion, so this is making it more realistic. So, first one. So we have a large financial services company, pretty large, $39 billion market cap. And so they have an attacker, cybercrime group successfully accesses their systems. And so it includes proprietary data and data relating to a small number of employees and contractors. They can't figure out if the data was actually exfiltrated or not. And so they've informed regulators about it. They've informed law enforcement about it. And so based on this, what are some things that you might want to know in order to figure out if this is material?
Yeah.
So I'm sorry, the type of data that was involved? Yeah.
Yep.
Okay, yeah. Right. How critical is this data to your operations? And so, yeah, absolutely. Yeah, did they actually plug the hole? You know, or is the data still leaking?
Time of incident till time of discovery.
Nice.
Yeah, absolutely. Absolutely.
Was any customer data impacted?
Yeah, I guarantee that they're regulated. The regulators are absolutely going to be asking that. So that's something you've certainly got to know.
Proprietary data, the named intellectual property.
Yep, because that it all has value. If it gets out the door, you know, it could impact the value of that. Any other questions here?
Are they still investigating the infiltration, or did they give up?
Okay, yeah. More?
What are their data classification levels? What does proprietary mean versus if they're confidential or more depths of their data classification?
Yeah, where is this in the matrix? Where is this in the matrix? So, you know, how far you know, to the right and up is it? It's certainly. And so in this case, let's say we have no customer data. We have limited amount of employee data. This was in a database that had a little bit of personal data related to employees, was not terribly sensitive. IP, nothing got out the door IP-wise that they're overly concerned about at this point. So, and disruption, I mean, they had, you know, minor disruption of operations while they were looking at this stuff, but they were still able to go from backup systems, they were able to go from alternative means and still continue operating, you know, at a slightly reduced rate during this time. So that give some ideas here. So who thinks this one is material and you need to be filing an 8K on this one? Got one? Okay, wait. Okay. And so we have one. Who thinks it's not material? Don't need to file an 8K on this one. Okay.
How many people are at the wrong conference? One. Okay.
Now, related question. You saw all these filings from before, you know, that said we don't think it's material or we can't determine if it's material, but we're filing it anyway. Anybody who is in that camp that said we don't think it's material want to file something, even though you don't think it's material, just kind of CYA.
Who wants to do that?
Okay. Okay, very good. Now I'm going to throw in one other complicating factor. Anybody read a recent Supreme Court case called McQuarrie? Okay. So McQuarrie case said, basically, it's a unanimous Supreme Court, fairly short opinion, so it's worth reading, probably a few times to get it clear. But the Supreme Court said that in order to bring an action under this Rule 10b-5, there had to be some actual statement that was made true or made untrue, or at least becomes kind of a half-truth based on the new facts that come out. And so if you say absolutely nothing on something, silence is not enough to bring an action under this rule. You have to have something that's stated before. And so this is very recent. This is just in the last few weeks. And so I would put forward this is that now it's been easy for companies to just say, okay, let's just go ahead and file, because then we're covered. We put it out there. But you also have to think about if you're making any statements there that may now not prove to be entirely true in light of what you found out. So it now comes with an obligation to keep that updated. Keep an eye on that and see as you move along, 3 months out, 6 months out, 2 years out, or it could be, like with Starwood, 10 years out. Is it now not true? So think about that when you're going through and doing it in that way. So
I think there are two things there that I found interesting about the McQuarrie case. Number one, it's a dizzying read explaining what the difference is between a pure omission, where I just don't say anything and it didn't matter, and a half-truth. And if you ever want to watch Supreme Court justices trying to parse out when something really was, you didn't say anything, and something was, well, you kind of didn't say anything, but it was a half-truth, right? And we all get that. Nobody here sells cars, used cars. All right, so that's the first point. The second point of that is we get a lot of questions, and here's how the question goes. Whose job is it to police all the public-facing statements of my organization? Is that counsel? Is that CISO? Is that the PR team? Is that somebody else? And these decisions directly implicate the answers that you're going to give of who's responsible for all these statements that are going out there. We have a question. You want to?
Well, one question. And I'm thinking in the future how this might change if I'm going to get on the technology side related to quantum computing and all the data that's out there that's encrypted now, but may not be when that comes out and the abilities get there. How is that going to change how they respond to this? Because now it's, well, yeah, they had the data from 20 years ago from one of our backup tapes. Well, now it's a risk or it will be a risk in the future. How do you disclose that? How do you
Is it reasonably foreseeable? We all know that right now, right, with just any types of hashes or any types of encryption, that there will be points in time in the future that those things, like, so for example, an encrypted password vault that may have had a breach 2 years ago, and let's just say 50 million encrypted password vaults are out there type of thing. Some of those are out in the wild right now and they're cracked because, yeah, right. But it is possible that in 5 years, in 10 years, in 20 years, you'll have this kind of like toxic tort thinking where actually the harm happens over an extended period of time, all potentially disclosable and things that you need to state. Yeah, good question. All right, what do we got, Jim?
And materiality deals with, is it important, to whom is it important, and when is it important? And it's that time piece that, and I don't know about you, but my crystal ball hasn't been working since the 70s. So, not to date myself.
Okay, Steve.
All right, so it's good to be an authentication company because nobody cares, right? If you are rendering authentication services to the world. So $18 billion, that's kind of a smallish company, right? We can think about that. Their customer support system was compromised, and that allowed access to customer support data on all company clients. So we were still getting paid. So no impact to our finances. It's just that all of our customers now have their information out in the wild. And if some of our customers suddenly can't open doors or log into systems or open cash registers, is that material for us? Just on that? Wow, I'm a good storyteller. All right, let me go back to the beginning. It wasn't us that, right? We're not affected. Are we? We will be. Yeah. Okay, well, that's fair. No financial burden on us. So financially, this isn't a risk. What type of risk do you think we're thinking about? And I have to disclose that? I mean, there are companies that would treat this as a boon, right? Hey, all press is good press. I still haven't convinced you? All right, anybody think that this is not material? And wouldn't report it? All right, nobody's taking the bait on that one.
I know. All right.
Okay.
All right. Scenario 3, you are a software company, 152 billion market cap. Software company, 152 billion. During an internal audit, there was discovered that there was a misconfiguration in the software that would permit access to passwords, ticket information, and personal information. So you're a software company, you provide essentially, let's just call it like a CRM platform to others. And during the audit, it's found there's misconfiguration. So all those notes about, oh, so-and-so called and they lost their phone and had to reset their phone and whatever, or X, Y, and Z customer wanted this thing and it wasn't good enough or it didn't arrive, or wow, we're on yet again with this client on X, Y, and Z. So access to passwords potentially, ticket information, and personal information. There is no known exploit of the vulnerability, right? Third line of defense, auditors doing their darndest. What questions do you have for me? What things do you want to know about?
There's no need to file.
Say it one more time.
There's no need to file.
Okay, he's just going straight for the, he's like, wow, I know she's the one
we're
for
good.
me. We're married. Okay, all right.
Everybody who's a public company in this room would need to file if that's the scenario.
All right. Well, what questions do we have? Any qualifiers? Yes, sir. What else do you want to know? It is software that is being sold to other organizations.
What is personal information?
Personal information is going to be the name Chris Pearson. He called in. He had a problem. He was user number 1234. His Microsoft Word's not working, so we did a this thing, a that thing, or whatever on his computer. Asked him if it was plugged in. It wasn't, and we fixed the issue. And the time in was 10:42 a.m. The time out was 11:02 a.m. And seems like a nice guy. And he went on his way. And we sent him the NPS survey. He hasn't responded yet. He doesn't like those. I don't know. So not disastrous, but that's what's in there.
Was there reasonable effort made to confront the third bullet point there?
Were there reasonable experts to go out there? Yes, we actually did. We hired a company, the one that we use internally for deep web, dark web type of stuff. We hired them to do a special project. Go out there and look in the forums for software that's been popped. Look for things that are out there. Look for vulnerability packs specifically written for our software, and they found nothing. We did it over 30 days. Pretty good stuff. Really good company. She's not buying it. Yeah. What questions do you have?
I just say reporting and follow up.
Okay. Are we all good on the question? Oh, one more question.
We'll have the passwords and then force change.
We did. Our marketing team spared no expense. Beautifully written, nice little picture, good Canva art in there, all the rest. Reset your passwords. We then waited, and some people didn't do it, and so we did a forced reset. Hey, you got it next time you log in, you got it this, and we even put a smiley face at the end of the marketing email. Yes, sir. Was there a CVE filed? On this one, since it's SaaS-based, there wasn't, because we just auto-updated everyone, and it went out to the masses. All right. Oh, yep, one more. Yes, it is. We are a big company, and it is big company software. All right. How many people would do nothing? Raise your hands. All right. How many people would go ahead and tell the SEC, you know what, something may have kind of sort of, we don't know. Our internal team, audit team is award-winning audit team, and external auditors, and the external dark web. We went ahead and scoured the earth, Mars too. Didn't find any indications of whatever. We don't consider it to be material. We don't this, we don't that, but we're letting you know. How many people would do that? All right. How many people are ready for mimosas? All right. How many people would go full-fledged, boom, this is major, we got to go, this is the whole ball and game here. All right, interesting. Oh, yeah, all right, okay. I don't see if there's anyone else. All right, cool. Good. All right, where are we off to, Jim?
Okay, another big company, semiconductor manufacturer, big market cap. So they have a supplier that experienced a ransomware attack. Didn't even hit them directly, but it resulted in some supply chain problems. So their shipments are impacted. They're not able to make everything according to schedule. And so they estimated that these lost shipments, delayed shipments, cost them about $250 million. And so, any other questions about this situation here? What else do you want to know? Okay. Oops. Supplier refuses to tell us definitively, but we understand that they actually they did pay the ransom, and for whatever reason they're back online after a loss of about 3-4 days worth of uptime. They're back online.
How connected are their digital ecosystems to
That's right.
Oh, a good point. Yeah. Well, in this case, actually, this is one where we have it. And so in the same quarter, we know that their net sales were $6.4 billion.
Do we conduct an internal risk assessment or anything to see if our systems were impacted?
Okay, yep. All right, so
Is the question limited to cybersecurity material or line of business material?
well, I mean, the guidance goes to cybersecurity, but your reporting requirements go beyond it. So if it's material, you got to report it. So with that, so anybody think this one's material? Do you want to? Anybody going to report this one? I can tell you in this actual case, this is one where they said it wasn't material. They reported it anyway.
All right.
So
we'll just read 5 and 6. We won't do questions. You can do the quick vote on them.
We've all woken up in the morning, gotten an email from our CEO, right, or purporting to be from our CEO, asking us to transfer tens of millions of dollars in a wire transfer, right? We've all done that. No? Okay, well, it's just me then. So, is it okay for me to say, but, realizing the error, I reached out to my banking partners and I got some of it back? And since it was tens of millions, anything I get back, that must not be material, because going back to Chris's, hey, no harm, no foul, that's a good rule, right? So how does no harm, no foul play into this? Is this material? Show of hands. All right, I've got to go make a phone call then. How many of you think this isn't material? Thank you, right? You just saved my job.
All right, scenario 6. Aircraft leasing company, $16 billion market cap, ransomware attack, tried and true. IT systems continue to operate, a little bit hobbled, but continue to operate. Big thing was a terabyte of data sucked out. It could be names, passengers, places they're going, where Taylor Swift's next location is, all of that. How many people think this is not material? How many people think it's material? How many people are doing so you're doing the SEC, so that last hand raised was SEC, I'm telling, doing a filing and saying material in that last one. All right, interesting. Cool. So we sped up through those other ones just so we can go ahead and do the final kind of closeout stuff.
Yeah, so let's talk about, let's apply what you've learned. So, Steve, you want to maybe give the first one there?
Yeah, so this next week, we'd like you to take a look at what filings or events have happened at your company, or perhaps somebody next to you, because it's always more fun to poke at your neighbor. What have you said? Right? And in this meeting, we've talked about a couple of things. Materiality is important stuff to somebody at some point in time. And as some of the questions have pointed out, we're looking at, if there's been an exfiltration, the quality of the data that's come out, right? Not all data is created equal. IP may be different, right? And we were talking about it earlier, if I have a honeypot and somebody took my honeypot, but all the data is false, does that make it a material incursion? We need to talk about that in the upcoming week.
Chris, you want to do the others?
Yeah, look, I mean, after that, make sure you're connecting internally. Make sure you're not just doing this from a cyber perspective. Inside counsel, outside counsel, CISOs, CFOs. They've been dealing with materiality for 22 years. Use them. External audit firms, use them. Bring people together. That's my kind of close in there.
Yeah, and I'll close with just, when you're talking about when you're going to make statements out there, stick to what you know. Don't speculate. Stick to what you know is true in these statements. And the company's going to come to you. When it comes to cybersecurity, if you're the CISO, you're the one who's going to be able to tell them what they know is true, or maybe we're not quite sure if it's true. So they're going to be depending on you for that, and that's what you've got to. And if they're not asking, volunteer it. Get involved in those conversations. Assert yourself. Because they need you for that. The CFO, they know materiality, they don't know cyber. So, and they need you to figure it out. So with that, any more questions? We've got all of 30 seconds to take them.
We'll hang around for a little while.
Can you guys talk a little bit about how all of this has increased the need for tabletop exercises amongst the executive ranks?
Tabletop exercises?
Oh yeah, absolutely, absolutely. Tabletops. And this is something you absolutely can tabletop. This is, you don't have to do just the incident itself. And I love tabletopping this stuff. A lot of this stuff involves the senior people, and the first one I actually love to do is leave the technology people out of it. Have the senior financial people, others, do an exercise where you go through the incident, and then they talk about whether or not to report the stuff. And then do a subsequent one where you bring in the CISO and the tech people, so that then they can query under, because if you bring them in the first time, they're just going to lean on you. They're
Bottom
going
line,
to expect you to do everything.
Use the scenarios. There's your tabletop. We already did it for you.
Yep. Well, personally, I'm a fan of outside counsel doing it because, well, we at least have this possibility of preserving it under privilege. So I think there is some advantage to doing it that way.
All right. I think we're at
We're over time, but we'll gladly take
Just
more.
a quick question. Event versus incident. I heard you guys use it interchangeably. So we have an internal churn about defining that, because as security leader, I get thousands of events per day.
Thank you, guys.
So which of them really turn into incident?
Yeah. Thank you all.
Yeah, I mean, where you define the terms, make sure you're using the term as you've defined it. And so that's certainly important to be doing that. And I think a lot of times, this is an area where there is, parlance among the security professionals that it's a term of art. And so the lawyers may not know the terms of art in this space, or the CEO may not know the terms of art. This is an area where you can educate them. On the other hand, they have terms of art in their space. The CFO, they have to absolutely have terms of art, and you need to learn what those are.
Thank you.
All right. Thank you, everyone.
Thank you.
All right.